Hello, everybody, and welcome to History/Law Bite number 256, dated May 19th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled The Eighth Amendment to the U.S. Constitution. The Eighth Amendment is one of the more famous parts of the Bill of Rights, and certainly is one that I would go so far as to say the average citizen has at least heard of. Okay, whether it be on the news or as a result of a court opinion, so forth and so on. So what exactly, does the Eighth Amendment do? Well, the Eighth Amendment has a single primary theme, and that theme is to prohibit excessiveness, all right, at the pretrial and sentencing phases of the criminal justice system, okay? And it applies to essentially the conditions of pretrial release and punishment as a result of a conviction for a crime. So let's read the text of the Eighth Amendment to the Constitution. The Eighth Amendment reads, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." And I know you've all heard the phrase cruel and unusual punishment at some point in your lives, and that is where it is derived from, the Cruel and Unusual Punishments Clause of the Eighth Amendment to the Constitution. The Cruel and Unusual Punishment Clause is one of the more famous parts of the Constitution in general, and one of the best safeguards against unduly harsh punishments, penalties being imposed against people as a result of convictions for crimes, okay? So a little bit of background, like the rest of the Bill of Rights, which contain common law and natural rights, the Eighth Amendment is effectively almost a duplicate of a provision in the English Bill of Rights of 1689, which substituting one word reads almost the same as our Eighth Amendment, all right? Instead of it saying excessive bail shall not be required, the version in the English Bill of Rights reads excessive bail ought not be required, okay? James Madison, however, substituted the word ought to shall, all right? And you get, virtually a duplicate. But the meaning, is virtually the same, all right? Prohibition on excessive, unjust action by the system, so to speak, before trial and as a result of sentencing, all right? It frowns upon excessiveness and harsh penalties, okay? That's what the Eighth Amendment does, all right? It's like a stop sign against excessive and unduly harsh treatment before and after trial, okay, as a result of sentence, okay? Limiting the power of the federal government and the state governments in their abilities to set bails and fines and even sentences in the applicable circumstances, okay? So, that being said, the Eighth Amendment has three clauses: the excessive bail clause, the excessive fines clause, and of course, the cruel and unusual punishment clause, all right? Going through all three, we start with the excessive bail clause. Now, the excessive bail clause, is one that particularly has, as it is described, a somewhat unsteady status with respect to its applicability to the states, but of course, as all of the Bill of Rights, it certainly applies to the federal government. And what it does is simply require that, bail is excessive and therefore prohibited by the terms of the amendment, if it is more or less a figure higher than is reasonably calculated to ensure the defendant's appearance at trial. All right. Now, bail generally, as it is commonly accepted in the states and on the federal level, should be proportionate, okay, to the offense committed, okay, and to, a significant extent as well, a defendant's ability to actually pay it. All right. Now, it would be viewed as, absolutely ridiculous and insane if someone faced imprisonment for stealing a candy bar or a television from a store and the judge imposed a $1 million bail. Wouldn't you think that was kind of excessive? Yes, so would I. The bail typically and should be, according to the excessive bail clause, proportionate and reasonable based on the offense. Enough, okay, to be grounded, reasonable, and not higher than what would be required to ensure the defendant's appearance at trial. All right. So basically, the underlying theme is reasonable. Okay, and it should not be higher than is reasonable to ensure the defendant's appearance at trial. All right. I know it might be repeating myself and sound redundant, but just to make sure that's understood as the Supreme Court has interpreted that particular clause. Now, bail of and in itself is not a right. Yes, you heard me correctly. Contrary to what you may have heard or what you may believe, bail, okay, is essentially a privilege given at the discretion of the judicial officer or magistrate or commissioner, whatever the official may be called. Okay, it is their right to give it to you as a condition of pretrial release. All right, but bail is not ordered. Nothing in the Constitution of the United States requires that any defendant be given bail. However, the Constitution does require that when it is given, excessive bail should not be imposed. Okay? So if a judge wishes to deny a, accused individual bail, then that person is going to sit until it's time to go to trial. All right? Unless they challenge that, But in general, so to speak, bail is not ordered. It is not a right. It is a privilege that can be given or not given, okay, to a defendant during a preliminary hearing, all right? And it is up to the judge to decide whether or not you are given that privilege, all right? If the state or the federal government considers you to be a flight risk, even to a mild extent, they may impose other conditions along with giving you bail, like turning in your passport and wearing an ankle monitor, things like that. Again, those are the conditions attached to it. We're all familiar with how bail works, at least to a small extent, all right? And, quite often the state, or the U.S. attorneys might request that the court deny bail to this accused individual. It's all up to the court to decide that. But it's not a right. It's a privilege. And as the court can give, the court can also deny. The Constitution only requires that bail not be excessive when it is imposed. All right? Now, the excessive bail clause is, essentially believed to have been incorporated to the states in 1971 in the case of Schilb versus Kubel, all right? And was referenced in the 2010 case, McDonald versus City of Chicago, with certain fundamental rights, all right, having been incorporated to the states, of which excessive bail was, the prohibition against it, rather, was mentioned in that case, along with other incorporated provisions of the Bill of Rights. All right? So that's excessive bail. So that takes us to the next clause, the excessive fines clause, which by its name, of course, prohibits excessive fines from being imposed, okay? That's defined more or less as prohibiting fines from being grossly disproportional, all right, to the gravity of a defendant's offense, all right? So if a court were to impose a, let's say, $100,000 fine, all right, as a result of, I don't know, failing to renew your tags on time on your vehicle, I think that could obviously run afoul of the excessive fines clause, all right? Or your driver's license was suspended and you were caught driving on a suspended license and the penalty for that was $100,000, all right? I think that would definitely run afoul of the excessive fines clause in the Constitution, all right? So fines, have to be proportionate logically to the offense committed, they cannot be ridiculously inflated, that resemble a crime far greater than what was actually committed, okay? The excessive fines clause is a pretty simple one, all right? And that was incorporated to the states via the 14th Amendment's due process clause in the case of Timms versus Indiana in 2019, all right? And last but not least, we have the cruel and unusual punishment clause. Now, this is the biggest bone with a lot of meat on it in the Eighth Amendment. Okay, so the cruel and unusual punishment clause, right, has a lot to it. Its primary functions, okay, are to, prohibit certain punishments altogether, outright, no matter what the crime is. Such punishments like being drawn and quartered, burned at the stake, broken on a wheel, being disemboweled, very ancient, barbaric punishments that derived, from medieval Europe, the whole purpose for the Eighth Amendment in general, to ensure that America would not replicate these practices, all right? And generally, the Eighth Amendment has served that purpose, okay? It also prohibits punishments for specific punishments for certain crimes, all right? Numerous cases, one in particular, Trope versus Dulles, overturned the practice of revoking American citizenship, all right, as a grossly disproportionate sentence, and ruled it the practice to be in violation of the Eighth Amendment's cruel and unusual punishment clause, all right? It also has a proportionality test and an evolving standards of decency test/review when considering whether certain punishments violate the cruel and unusual punishments clause, all right? So highlights in the cruel and unusual punishment clause happen when, the laws affect particular groups, such as minors, the mentally disabled, certainly in capital cases. Oh my gosh, and that's where a significant amount of cruel and unusual punishment litigation has been directed in capital cases. And the court has certainly used that clause to limit the applicability of the death penalty over the past 45, 50 years, okay? Another area where it has been used a lot is in drug cases, all right, where many states have, through time, imposed very high sentences for drug offenses that were substantially, disproportionate to the actual crime itself, and, the proportionality test it was applied, and some have been sustained, others have not. But in any case, it's an area where the court has certainly reviewed the laws in question with a lot more scrutiny, all right? So essentially, the clause requires that punishments, all right, at least in some form, some way, all right, be tailored to fit the crime itself and not excessive in length or severity. Laws that run afoul of that immediately come into question under the Constitution, virtually from the moment they're enacted, all right, though they may not always necessarily be challenged, all right, and that's what it takes. All right, so this clause, the Cruel and Unusual Punishments Clause, was incorporated in 1962 with the case of Robinson versus California, all right, and has been applicable to the states ever since that time. Now, the Eighth Amendment, like all of the rest of the Bill of Rights, has been defined substantially and very fluidly through hundreds of U.S. Supreme Court decisions throughout the years. And that, folks, is where you get the bulk of understanding of just how deep the Eighth Amendment goes, how far its reach is, and the areas that simply are seemingly out of bounds. All right. Now, many individuals have argued that capital punishment of and in itself is unconstitutional under the Eighth Amendment and its Cruel and Unusual Punishment Clause. And, although I don't agree with that, despite of being an opponent of capital punishment, many assert that principle to be true, as the way capital punishment is applied, in a very disproportionate manner. Also, the how it is applied has also been challenged. It is all viewed by some as being against the Constitution. And like I said, I don't agree with capital punishment at all. It is very racially biased, and it is anything but fair. Okay, not to mention it is retributionary killing, which does not return anyone back to life. So I don't agree with it, but I also do not agree with the concept that it is in violation of the Eighth Amendment, because it is specifically endorsed by the Fifth and 14th Amendments as long as due process is used. But that is another argument, and I did do a video on that very subject. So that is the Eighth Amendment in a nutshell. Not too bad, see, not too difficult. Pretty much simple and straightforward. This was just an overview of the basic, principles of the Eighth Amendment, what's generally allowed, what is generally disallowed. And, like I said, to get a greater perspective and more in-depth insight on the amendment, we cover various cases, all right, Supreme Court decisions that have been decided under the excessive bail clause, the excessive fines clause, and the Cruel and Unusual Punishment Clause, all right? And so once again, in a nutshell, the amendment prohibits excessive bail, excessive fines, and cruel and unusual punishments, all right? To what extent each of them go is defined by case law, all right? So that wraps this summary overview up of the Eighth Amendment to the U.S. Constitution. If you have any questions or controversies, leave them down below. I'll be happy to answer them. If you like this video and gained a thing or two from it, learned something, drop me a like. I'd graciously appreciate that. And if you have not subscribed to my channel, I humbly invite you to do so right now so that you can keep on learning. Thank you again so much for listening. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.